So, in another case of Kotak Mahindra Company's case, the court went ahead and said that even if possible, court should conduct a summary inquiry into determination of paying capacity of the offender. And most interesting thing was in NEPC Micon Limited case, where application of mind, while calculating compensation, whether there is a need to have an application of mind, and the court affirmed it vehemently, and they said if any decision which withdraws blood and life from a provision like 357 should be avoided. So, that is why application of mind is mandatory. Limit of compensation. So, whether the amount of compensation should be limited or it should be have a cap, maximum cap. 357 does not lay down any such cap, but there are various limiting factors which bring down the amount of compensation, like reasonability. The principle of reasonability fixes the amount of compensation based upon the earlier principles which we have discussed. Then the paying capacity of the accused, then the gravity of the offense, needs of the victim's family. So, these are certain factors which limit the payment of compensation. Now, let me move on to the last but one aspect of my discussion, that is critical analysis of this CrPC provision. When you take a glance through this act and the legislations, one factor which we cannot be missed out, that is the judiciary as well as the state has got the least priority as far as victim compensation is concerned. Even though ours is a welfare state, the payment to compensation to the victim is of our least priority. Second, the problem with the judiciary is that when we talk about optimum and substantial justice to the victim, they talk about unjust relief to the offender. So, when you balance between the two, rights of the accused and rights of the victim, when you talk about right to punish the accused and right to compensate a victim, there the judiciary tilt in favor of offender, the accused. So, that is the reason again these provisions are not taken with proper vigor. Then payment of compensation under Probation of Offenders Act and other things, where it is possible only when a crime fulfills both the requirements of tort as well as the crime, and that is again condition which limits the scope of section 357. Victims compensation lacks proper motivation. Again, when I say lacks proper motivation, it is in favor of judiciary as well as legislature. It does not ensure speedy and sure relief. The trial period are too lengthy, so victim survival throughout the trial period is again questionable. The interim immediate compensation, that concept does not exist in most of the criminal proceedings. That only one exception is the motor accidents claim cases, where immediate compensation is granted, some reasonable amount is granted. So, then 357 exclusively talks about offenders liability, but one thing, major thing that is missing is state liability. So, state is not held liable under any circumstances, only offenders are held liable. The emerging theories on victimology, actually it is assisting and it is improving the grants in aid by the state as well as the victimology assistance process is improving day by day. 358, again another provision which talks about abuse of power by the state and compensation is paid by the state. And interesting thing is, once compensation is paid by the state is authorized to recover that money from the erring official, the official who has made that mistake or who has committed that wrong. So, again these provisions are there, but they do not find a favorable judge. So, during the trial process it has never been taken seriously. Courts are offender oriented. That's another major issue with our whole process of victim compensation. So the beautiful saying goes like this: victimological knowledge has not flown into the penological corridors of magistrates. So magistrates are still immune from that victimology thinking process. Law Commission of India is also been trying to introduce this victimology, and it has made an observation saying that courts are not particularly liberal in utilizing these provisions, and it is regrettable that statutory provisions, that is existing statutory provisions, are not being put to use. So Supreme Court also had made many appeals to the courts to use this power liberally to meet the ends of justice in a better way, and again cautioned it that it should not be unduly excessive, and calculation of the amount should be done. After calculating the amount, fix a little higher amount than the actual compensation and impose it as a fine. So these are the few directions which the Supreme Court has given as relating to this. As a final leg of my lecture on victims and access to justice, I am going to discuss the conclusion. Now, conclusion, I am going to talk about the improvements that is required, or I should add it as saying that what is the future that is there in the case of victims' rights to justice. 357A, first thing is it should be implemented liberally, and maximum utilization should be taken by the court, and victims should be compensated properly. Secondly, there is a provision of proceeding criminally as well as civilly, but one thing we should also consider, that victims are already victims of a situation, and now they are going to be victim of a judicial system, because they are expected to fight case at two different levels, one at criminal level and another at civil courts. So to avoid that, if 357 is implemented effectively, then the civil court provisions or civil court proceedings could be avoided completely, which would in turn benefit the victims by saving time as well as saving expenses. High courts must orient their judicial setup or judiciary or the subordinate judges towards compensatory criminal jurisprudence and provide compensation to the victims of crime. So here I come to the end of my discussion on access to justice and the victim. Feel free to contact me. If at all any queries are required, email me or email to the forum that has been established under this. I would be more than happy to respond to your queries. Thank you very much.